Going over Form SSA 1693, which is the fee agreement for representation before the Social Security Administration. Most likely, unlike other videos that we produce on this channel, this will probably be a form that you'll complete with hand in hand with someone that you're asking to serve as your representative for Social Security Administration representation purposes. So this likely might happen in the case of something like a disability claim, where there's a long and arduous process that may involve multiple levels of denial or appeals, representation, and you decide that you're going to hire a firm to kind of walk you through or even just do the process on your behalf. So firms don't do this for free. They normally charge a fee, and that fee is regulated by the Social Security Act. So before we get into the form, which is relatively straightforward, we're going to take a moment to discuss a little bit about this paperwork so that you understand what you're getting into when you file it. So everything that we're about to discuss is on the form itself. We're going to slow down, we're going to take a step back, and we're going to walk through each of these explanations so that you have a better understanding, because it's important for you to recognize what you're getting into when you are approached by someone that says they can help you, or if you approach someone and they're telling you that you have a case. So, you and your representative can come to an agreement on a fee that is either a flat dollar amount. So if someone says, hey, I've taken a look at your case and I can represent you, I'm confident that we can win your case and get you back benefits, but we're going to charge you $5,000. You can pay a flat amount, or you can pay a certain percentage of total past due benefits that you may be awarded if you have what's considered a favorable outcome. So, however, before you go through that process, the Social Security Administration needs to process your fee agreement to make sure that it complies with the Social Security Act, and that you are not being taken advantage of. That's the entire reason. So, and it actually says your representative must file your fee agreement before they issue a favorable decision. So if you submit the fee agreement after the decision, then they're going to approve it, and it has to be submitted and then approved. So the fee can be it is regulated by law, so you can pay up to a maximum of 25% of your total past due benefits, or a flat dollar amount, as indicated by the Social Security Administration. As of the time of this recording, the most recent version of this form was issued in November of 2022. So there's probably going to be a new version of Form SSA 1693 coming up in the relatively near future. But as of that date, the maximum flat dollar fee was $7,200. So, however, you can pay more under a couple of conditions. So first, the fees, if this goes to court, your representative may ask the court to authorize additional fees for additional work as they justify. And if that happens, then the judge in that case can authorize certain additional fees at their discretion. The other aspect of this is that they can also ask you to pay out-of-pocket expenses. For example, if you bring in the proverbial stack of doctor's records and they have to make copies, that incurs a cost, and that's a cost of labor, because someone's going to make those copies, and then the actual cost of raw materials, the use of a copy machine, paper, ink, so on and so forth. So the SSA has nothing to do with authorizing those fees. One of them is authorized by a federal court through that process, and then the other one is simply what your representative is going to deem to be out-of-pocket expenses. So a couple of other things you should know. There can be a two-tiered fee agreement, which basically means that the higher your case is escalated through the appeals process, through certain administrative levels, you can agree in writing that if your case is appealed beyond a certain level, and that will be determined on that form, then the current fee agreement is nullified, and your representative can file a fee petition to the Social Security Administration. So let's say you agree to a fee of $5,000, but you have a two-tiered fee agreement, which means that if it's escalated above, a certain level, then you basically tear this fee agreement up. They will issue a fee petition based on what they think they should be awarded, and then the Social Security Administration will separately approve or disapprove at their discretion that separate fee. So you can choose that option, and that allows your representative a little bit of additional kind of, financial security in case they spend a lot more money on your case than they anticipated. But they're still held accountable for the standard fee agreement that you've put into place until you reach that higher level of escalation. Trust and escrow accounts, they can accept money from you before the Social Security Administration authorizes a fee. They would hold it in a trust or an escrow account, and then once the Social Security Administration approves that fee, then they would be able to charge that in the case of a favorable outcome. Third-party payments. So your representative might receive payment from a third party. It could be in lieu of your fee agreement. It could be in addition to your fee agreement. And if your representative is eligible under the Social Security rules to receive an authorized fee directly from the Social Security Administration, they'll withhold 25% of your retroactive benefits to directly pay that fee. However, you would have to pay the authorized fee under certain situations. If the amount of the fee that the Social Security Administration approves is more than what was held in that trust or escrow account, if it's more than the amount that they can pay from your past due benefits, if the Social Security did not withhold past due benefits, if you did not receive past due benefits from your claim, if your representative is not eligible under direct deposit rules or under the rules for direct payment, or if you ended the representative's appointment before a decision was made, any of those situations may result in you having to pay your fee directly out of pocket. So, a couple of other situations. If they withdrew, they could still charge you under certain circumstances. If they were disqualified, if the Social Security Administration withheld but then released your benefits because your representative did not ask for their approval until 60 days after the notice of award, or they did not timely tell the Social Security Administration that they planned to ask for a fee. So signatures, if you're appointing multiple representatives, they can all sign. There's an addendum form on the back that shows additional fields for additional representatives. They can put their rep ID number, they can put their name and sign it. However, all representatives on that single fee agreement are responsible for upholding, basically the intent of that. There's a Privacy Act statement that says, that they can use your information in certain ways. They collaborate with other federal agencies. They share your information with the Internal Revenue Service. They can share information with your representative to the extent necessary to dispose of a fee petition or an agreement. They would be sharing your information usually with your representative anyway, simply because they're representing you. And you've probably already granted them permission on something like Form SSA 1696, which is the appointing of representation form. See, according to this Paperwork Reduction Act statement, it should take about 7 minutes to read the instructions, gather the facts, and answer the questions. It probably won't take that long simply because your representative will have pre-filled a lot of these fields. So we're going to go through this. We can fill in fields and pretend that we're applying and making this application on the spot. So the rep ID, you don't need to worry about that. So in this case, John Doe is representing the client. So this is the representative's information. So he's putting it in, oh, sorry. There we go. Now we're going to enter your social security number as the claimant. And he lives right next door to John Doe. That's convenient. So you'll want to make sure that this information is correct. You're going to want to double check it. You're definitely going to want to make sure that you have copies of everything, and your representative should take care of a lot of this stuff for you. So there shouldn't be any issues with this. For some reason at the top of this, I can't fill this in. So the standard fee agreement, you're going to choose one of these two. So again, your representative should basically outline, what it is that you're going to pay. So you're either going to agree to pay the maximum fee, which is either $7,200, or you're going to pay a certain flat dollar amount, say $5,000, or 20%, right? There you go. So now you're supposed to read and acknowledge that a couple of things. One, the Social Security Administration may authorize fees based on past due benefits awarded to a spouse or a beneficiary that may receive additional benefits, but they did not represent them. The Social Security Administration can still authorize fees subject to the maximum dollar amount. So, basically there's, all of those beneficiary payments, they're still subject to the maximum dollar amount, in this case $7,200, until that fee is upward adjusted for inflation. So you have the right to protest this fee agreement within 15 days. Any party can. And then your representative may still request a fee even if the case does not result in benefits, if it's not a favorable decision. So they can file a fee petition if the fee agreement cannot be approved because there are no past due benefits. So the Social Security Administration doesn't authorize out-of-pocket costs, those are directly payable to your representative. So we'll talk a little bit more about those expenses. So the two-tiered fee agreement, this is, oh, by the way, you'll be asked to initial this. So the two-tiered fee agreement, this section will probably be pre-filled by your representative. So they'll insert the administrative level that they feel they can file a fee petition to the Social Security Administration. So if you have to go through multiple appeals process, this allows them to continue doing that, knowing that once you actually get your favorable decision, they're entitled to a larger fee simply because they had to put in more work to get you that money. So the escrow or trust accounts, so the top block basically says that your representative will establish an escrow account. Again, this is not a direct payment, it's an escrow account, which means they don't get paid until your fee is approved. And then the second one indicates that your representative will receive a fee from another party. So this could be a state, county government, could be private entity, and you're saying that you'll not pay a fee unless the Social Security Administration authorizes the entire thing. So, and only representatives that have been properly appointed can be authorized to receive a fee. So you can make sure that you're not paying a dime until you get an approved copy of this back by the Social Security Administration. That doesn't indicate that they're going to win your case for you. It does indicate that they've at least done a little bit of the preliminary work. They're registered with the Social Security Administration, which means that there is someone keeping an eye on their record, and they're a little bit more trustworthy than someone that is not registered with the Social Security Administration. So, and then page 5 on the back simply contains additional spaces for additional representatives, their name and signature. So if you're working with a law firm and there might be multiple lawyers that are working on your case, each of them would have a rep ID number, and then they would enter your name and their signature on this form. So, so that's kind of the basics behind Form SSA 1693. If you want to know more about this form, you can go to our website where we cover this in a little bit more depth. Again, you should probably be able to get a rundown from the representative. They should slow down the conversation so that you understand everything that you're about to sign and put your name on. However, if you want to break it down a little bit more, we do cover this in an article. Simply go to teachmepersonalfinance.com, type in Form SSA 1693 in the search bar, and you'll see this article. If you like our articles, please subscribe to our newsletter, and if you like our YouTube videos, please subscribe to our YouTube channel. I do have one more point, because there was a question that I was asked whether or not this form allows someone to represent you in front of the IRS, and it does not. The IRS has a separate authorization form for people that represent them before the IRS, and that's called IRS Form 2848. That is their power of attorney and declaration of representative form. So we'll put a link to that video and article in the show notes, just in case you're curious or you have that question. So if you have any additional questions, or if there's a topic that you would like me to cover in an upcoming video, please post your question or comments in the show notes in the comment section. Thank you very much, and have a great day.